Hello everyone. It's 8 sharp 8 a.m. in the morning, and we will continue discussing the previous year question paper of Delhi Judicial Service preliminary examination that was held in 2017. We have already solved up till question number 50, and we will continue from question number 51 onwards. Let's read what question number 51 says. What are the obligations of a person making an arrest? What are the obligations? कर्तव्य क्या बनता है? First, to inform any friend, relative or nominee of the arrested person of the arrest and place of detention. Second, to inform the arrested person of his right under first, that you have this right. Third, to make an entry in a book kept in the police station that information as required by first above has been given. Fourth, none of the above. The right option is option 4. What are the obligation of a person making an arrest? Um, Here in the answer key, I am the answer is showing that is 4. That is none of the above. But according to me, the answer gonna be wait, to make an entry in a book kept in the police station that information as required by first above has been given, and to inform, according to me the answer should be third, because the third point covers first as well as third. So you have to make an entry, diary entry, in which you have to mention all the details regarding the arrest thing. And apart from that, whenever you are going to make an arrest, then it is the police obligation. It is the police's duty to inform that whoever to whom he is arresting, to inform his friend or relative or nominee of the arrested person, okay, about the arrest and the place of detention. So according to me, the right answer should be third. Question number 52. If a court has reason to believe that a person against whom a warrant has been issued and the person is either absconding or concealing himself so that the warrant cannot be executed, then a court may issue a proclamation against him. That person should be an accused person, a surety, a witness, all of the above. 50 seconds, right option is 4, that is all of the above. The person can be an accused person, a surety, or a witness. Question number 53. A search warrant may be issued. A search warrant may be issued where a court has reason to believe that a person would not produce a requisition document. Second, where the court does not know if a document is in possession of a person, where the court considers that the purpose of any inquiry or trial will be served by a general search. Option 4, that is all of the above. The right option will be option 4, that is all of the above. Question number 54. If any person having sufficient means neglects or refuses to maintain his father or mother, a magistrate may direct that person to pay a monthly allowance to his father or mother, cause him to be arrested, forfeit forfeit his source of income, or punish him for contempt of court. The right answer will be first, that is, direct that person to pay a monthly allowance to his father or mother. Question number 55. While recording a confessional statement, a magistrate shall ensure. While recording a confessional statement, a magistrate shall ensure that he explains to the person making the confession that he is not bound to make a confession. Second, that a police officer is present nearby so that the person making the confession does not run away. That if the person does not make a full and true confession, he is kept in the custody of the police until he makes a proper confession. The right answer is first, that is, that he explained to the person making the confession that he is not bound to make a confession. Question number 56. If an investigation into an offense is not completed within 24 hours, then depending on the nature of the case and prevailing situation, a magistrate may remand a accused to the custody for 15 days, 15 days, 60 days, 90 days, all of the above. The right answer is first, that is 15 days. Wait. Sorry. Its right answer is four, that is all of the above. So the magistrate may send accused for on remand for 15 days or 16 days or 90 days, but not more than 90 days. So the right answer is fourth. Question number 57. A magistrate may take cognizance of an offense. A magistrate may take cognizance of an offense upon receiving a complaint of facts which constitute such offence, or upon a police report of such facts. Third, upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed. The right option is four, that is all of the above. Question number 58. If a public servant acting in discharge of his public duties makes a complaint to a magistrate, then the magistrate must examine him on oath about the contents of his complaint, need not examine him. Third, may dismiss his complaint if there is no witness present on his behalf. Fourth, must examine him and his witnesses on oath before issuing process. Wait. If a public servant acting in discharge of his public duties make a complaint to a magistrate, then the magistrate make a complaint to public servant. Then he need not examine the magistrate may need not examine him. Question number 59. Classification of offences into compoundable and non-compoundable is provided in schedule first, schedule second, second A, none of the above. Question number 60. An application for a plea bargain cannot be made by an accused person where the offence is punishable with imprisonment for a term exceeding 7 years, where the offence has been committed against a woman, where the offence has been committed against a child below the age of 14 years, all of the above. I'm sure about this and I'm sure about this. So अगर ये दो हैं that means ये भी होगा. एंड 7 में मुझे थोड़ा सा 1% डाउट है, ओनली 1%. 99% आई एम श्योर कि मैंने 7 years देखा था इंस्टेड ऑफ 10 years. तो 7 years है, तो अगर ऐसा है तो fourth, we will go with fourth, and this is the right answer for question number 60. See question number 61. The participants in a plea bargain must include the police officer who investigated the case, the accused person, the victim of the offense. Fourth, all of the above. The right answer is all of the above. Police officer as well as the accused person or as well as the victim. Question number 62. In a case triable by a court of session, if an accused does not have sufficient means to engage a pleader, the court shall adjourn the case until the accused can arrange a pleader for himself, proceed with the case ex parte, assign a pleader for his defense at the expense of the state, refer the case to the state legal service authority. इन दोनों में से कोई एक होगा. The right answer is option 3, and that is to assign a pleader for his defense at the expense of the state. Okay, so the right option is option third. Question number 63. No court shall take cognizance of an offence after the period of limitation, which is 6 months if the offence is punishable with fine only, 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year, 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Fourth, all of the above. The right answer is all of the above. 6 months punishable with fine only, 1 year, imprisonment not exceeding 1 year, 3 years, if the offense is punishable with imprisonment exceeding 1 year, but not 3 years. All of the above. Question number 64. An offense punishable with imprisonment for a term exceeding 2 years is triable as an offense punishable with imprisonment. Punishable with imprisonment for a term exceeding 2 years is triable as summon case, warrant case, first and both first and second above, none of the above. The right answer is second, that is warrant case. Question number 65. A metropolitan magistrate may pass a sentence not exceeding metropolitan, chief metropolitan first class. The right answer will be first, 3 years. Question number 66. Where a person is convicted of an offense, which provides for imprisonment with fine, where a person is convicted of an offense which provides for imprisonment and fine, then in default of payment of fine, the maximum further imprisonment that can be awarded by a court is 3 months, one-fourth the maximum sentence for the offense, half the maximum sentence, none of the above. Right answer is one-fourth. Question number 67. An act committed by a child is not an offense if he has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct on that occasion, and if he is between the age of 7 years and 12 years, below 7 years of age, wait, below 7 years, between the age of 7 years and 14 years, ये तो definitely नहीं है. None of the above, ये भी नहीं होना चाहिए. क्वेश्चन एक बार फिर समझ लो. An act committed by a child is not an offense if he has not attained sufficient maturity of understanding to judge the nature and consequence of his conduct on that occasion, and if he first between the age of 7 years and 12 years. Question number 68. An unlawful assembly must consist of at least 3%, 5%, 7%, none of the above. Right answer is at least 5%. Question number 69. Section 320 of the IPC, that is Indian Penal Code 1872, 1860, that was the implement was from 1872. So section 320 of IPC explain what is a grievous hurt. Which of the following is grievous hurt? Hitting someone with a hockey stick, hurting the religious sentiment of a person, emasculation, or none of the above. Or 69, hurting hockey, emasculation. The right option is option third, that is emasculation. Question number 70. Wait. Emasculation. If you want to know what is emasculation, the removal of male reproductive organs. This is called emasculation. Question number 70. A child of 10 years of age does not have any parents or any lawful guardian. He is whisked away by somebody that a person is said to have committed an offense of kidnapping, abduction, trafficking in children, none of the above. The right answer is abduction. Question number 71. If a man has voluntary sexual intercourse with a married woman, he is guilty of adultery. The married woman is liable to be tried as an abettor, adulteress, co-accused, none of the above. The right answer will be option 4, that is none of the above. Question number 72. When a criminal act is committed by several persons in furtherance of a common intention, then each person is liable for that act. Each person is liable for that act as if it were committed by him only. Each person is liable according to his role in the commission of the offense. None of the above. The right option is option second. Question number 73. Under section 498A of IPC, cruelty includes any willful conduct that is likely to drive a woman to suicide, any willful conduct that is likely to cause grave grievous injury or danger to the limb of a woman. Third, harassing a woman for her inability to meet an unlawful demand for property. Or fourth, all of the above. So its right answer will be fourth, that is all of the above. Question number 74. The maxim ignoratia juris non exusat means ignorance of law is an excuse. Ignorance of law is not an excuse. Ignorance a law is an excuse. Ignoring a law is not an excuse. इसका मुझे सर्च करना पड़ेगा. Ignorancia juris non cusat means is a Latin maxim that translates ignorance of law is no excuse. Its right answer will be option B, that is ignorance of law is not an excuse. मुझे थोड़ा डाउट था, ये वाला तो होता ही है, इंग्लिश में होता है ignorance of law is not an excuse, बट आई थॉट कि क्या इसका मतलब ये भी निकल सकता है क्या, ऐसा भी अगर ये भी निकल सकता है तो फिर इस वाले के लिए कौन सा फिर मैक्सिम होगा, दो हो जाएंगे, तो वो थोड़ा डाउट था मुझे. क्वेश्चन नंबर 75. If five persons accost a person and take away his wallet at knife point, they are guilty of theft. Five person. How many person are there? Five. Na? Dacoity, robbery. Robbery can be um, at least 4% if done by the maximum 4%. So here there are 5%. So dacoity. Question number 76. Culpable homicide is not murder if it is committed under grave and sudden provocation, a state of intoxication, an irresistible impulse, grave and sudden provocation. All of the above लग रहा है. Grave and sudden provocation, a state of intoxication, an irresistible impulse, or all of the above. The right answer will be culpable homicide is not murder if it is committed under grave and sudden provocation. Question number 77. An expert witness is one who can speak very fluent English, has written books, has done a doctorate, is especially skilled in the subject in respect of which he has been called upon to testify. Right option is option 4, that is whatever it is written. Question number 78. Judicial notice can be taken of Judicial notice can be taken of Jeremy Bentham being a great jurist, H.F. Hussain being a great artist, Amitabh Bachchan being a great actor, none of the above. The right answer will be option 4, that is none of the above. Question number 79. Secondary evidence include certified copy of a court order, copy made from or compared with the original, oral account of a document from a person who has himself seen the document, none of the above. The right answer will be second, that is copy made from or compared with the original one from primary document. See question number 80. Which of the following documents are public document? Documents forming the acts or record of the act of tribals, documents forming the acts or records of the act of public officer, documents forming the act or record of the act of judicial officer, fourth, all of the above. Question number 81. An inscription of a metal plate is a document, fact, opinion, or motive. A document. An inscription of a metal plate is a document. Uh, Give me a break of 15 to 30 seconds or 1 minute. See the next question, question number 82. A is accused of committing the murder of B. Which of these is a relevant fact? First, A was seen going to a field with weapon of offense. Second, A told his friend that he would avenge his father's death. Third, A was seen running away just before the arrival of the police. Fourth, all of the above. The right answer is fourth, that is all of the above. Question number 83. To be admissible, a dying declaration may be made to any person, must be made before a magistrate, must be made before the investigation officer, must be made before the doctor. It can be any, the person can be anyone. So the first option is the right option. Question number 84. The burden of proving a crime is on the accused, who must show his innocence, both the parties. Generally, if we talk about generals in a general sense, then on the prosecution. Question number 85. A test identification parade should be conducted by a magistrate, a police officer not below the rank of sub inspector, any person, all of the above. The right answer will be first, that is that is a magistrate. Question number 86. X is found in possession of some currency notes recently stolen from a bank. Is it correct to presume that X has stolen the money? That X has received the currency knowing it to be stolen? Third, both of the above. Fourth, none of the above. The right answer will be X is found in possession of some currency recently stolen from a bank. Is it correct to presume that X has stolen the money? That X has received the currency? Both can be the right in this situation. Both option can be right. So we can't deny. So we will go with option third. Now here are the directions. There is a statement against each of these questions. Read the statement and confirm whether it is true or false. Make the answer as first for true, second for false. Question number 87. Under the rules of the Delhi High Court, the cause list is kept in an electronic form. There is a presumption of its genuineness. First, true. Second, question number 88. The IPC applies to an Indian citizen who commits an offense outside India. First, true. Question number 89. Whoever being under a sentence of imprisonment for life commits a murder shall be punished with death. Whoever being under a sentence of imprisonment for life commits murder shall be punished with death. True. Question number 90. Making preparation for committing dacoity is an offense. Making preparation for committing dacoity is an offense under the IPC. True. Solitary confinement is permissible in India. Solitary confinement, I think two. False. Solitary confinement. Solitary, yeah, it is uh, परमिसिबल इन इंडिया. किसी किसी नेता को ज़रूरत पड़ती है, डाउट रहता है तो उसको कन्फाइनमेंट में उन्हीं के घर में उनको कन्फाइन कर देते हैं, डिटेन कर देते हैं. सो इट इज़ परमिसिबल इन इंडिया. Question number 92. In a criminal case, the fact that a person has a good character is relevant. In criminal case, in criminal as well as in civil both cases, but criminal case में उतना मैटर तो नहीं करता है, but फिर भी we will go with first, that is true. Question number 93. The Indian Evidence Act 1872 provides for the admissibility of electronic record. The right answer is first, that is true. अभी हो गया है. Question number 94. A non-secure digital signature of a subscriber is required to be proved. True. 95. Documentary evidence includes electronic records produced for the inspection of the court. True. Question number 96. On what date was the Constitution of India adopted? On what date was the Constitution of India was adopted? 26th November. कुछ पोर्शन जो है 26 नवंबर को इम्प्लीमेंट हो गए थे. बाकी जो रिमेनिंग थे वो 26 जनवरी से हुए थे. Question number 97. The directive principles of state policy are justiciable. ये आया मेरे ख्याल से था, ये आयरलैंड से आया था, आयरलैंड के कॉन्स्टिट्यूशन से, इफ आई एम नॉट रॉन्ग. यहाँ पे क्या पूछ रहा है? द डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी आर जस्टिसेबल, नॉन जस्टिसेबल, नेगोशिएबल, नन ऑफ द अबव. नॉन जस्टिसेबल. आई डोंट थिंक सो. कैन आई चेक दिस वन? The directive Principle of justice policy are. Yeah, it's not justiciable. This is the right option. Question number 98. A judge of a high court is appointed by the President of India, Chief Justice of India, Governor or Chief Governor of a state or Chief Justice of a high court. Judge of a high court is appointed by President of India. Question number 99. When the Supreme Court exercises its power of judicial review, Supreme Court exercises its power of judicial review. It first reviews its own judgment. Second, it reviews the functioning of the judiciary in India. Third, examines the correctness of an administrative action or the validity of a statute. Fourth, appoints a committee to review the working of the constitution. The right answer is option third, that is examine the correctness of an administrative action or the validity of the statute. Question number 100. Every person arrested and detained in custody shall, every person arrested and detained in custody shall, excluding time for journey, be produced before a magistrate within 24 hours of the arrest. बाकी ऑप्शन क्या है? 14 days of the arrest, only when his bail application is listed for hearing, none of the above. Right option is first. Okay. Now we will discuss from question number 101 to 126 or 125 or 150 in our next video. It is sufficient for today for this video. Okay, till then, have a good time.